Okay, happy Tuesday. Thank you for joining us today. Welcome to DC Construction's first webinar. We're going to go ahead and get started. Title of our webinar today is How to Get Paid, Tips and Tricks for Construction Companies in DC, Maryland, and Virginia. We're going to be looking at payment enforcement techniques here in the DMV. Just to help everybody out that's in the industry, because it's a tough business and sometimes it's hard to get paid. Before we move on, I'd like to say a big thank you to Alan Herencia with DC Construction for letting us do this. We're very honored to be doing the first webinar for the group. It's a very fun, active group that's all about helping people out, and we're happy to provide some content for them. And I will say that I've talked to Alan, and DC Construction has a lot of other ideas in the pipeline, more webinar topics that'll be coming your way soon. So it's very exciting. So let's get started. My name is Jackson Nichols. I'm an attorney in Cohen Seglias' construction group. I'm based in our Washington, D.C. office. We have offices all up and down the Mid-Atlantic region. Our main office is in Philadelphia, but we've got a New York office, Pittsburgh office, offices in New Jersey and Delaware as well. I advise general contractors, subcontractors, sureties, owners, and other construction industry entities in navigating complex disputes as part of my practice. If you guys have any questions, you'll notice that there's a little chat feature. Go ahead, and if you think of any questions along the way, you can type those into the chat feature, and I'll either try to address them at the time if I see them, or I'll try to get to them at the end. And we'll try to save a little time at the end for questions. Okay, so our topics today are payment enforcement techniques, and we're looking at mechanics liens principally, because that's one of your best tools. We're looking at bonding. We're looking at prompt pay statutes, and we'll be focusing on just the jurisdictions of DC, Maryland, and Virginia. Okay, so getting paid, you've got standard techniques that you're probably used to. You might not think of them as techniques, it's just how you do business, but first is you of course provide your pay apps every month, generally is how it works. And if you're not getting them paid right away, usually it's a conversation. If you feel like you need to push things a little more, you can always send a demand letter. And if you really want to push things, as a last resort, you can file a lawsuit. And most people are pretty aware of those standard practices, but you've got other techniques that are made available to you because, in the construction industry, there's not necessarily a level playing field. And if you're one of the downstream entities, like a contractor in a dispute with an owner, or if you're a subcontractor in a dispute with the contractor that hired you, they're usually bigger than you are, and they have more favorable contract terms. So the legislatures have seen fit to create additional tools for the downstream contractors, and those can vary a lot from one state to the other. And so these are things that are outside of your traditional letter writing campaign or breach of contract type of legal action that you could bring. So, the additional leverage that you get is going to vary depending on what type of job it is. So if you've got a mechanics lien, if it's a private job, the mechanics liens are usually, they're statutory creation that are present in pretty much every state, but they don't exist in common law, so you don't automatically get a right to them. It's something that each state has decided to create specific rules for how you can go about and get a mechanics lien. And those rules vary pretty widely from one state to the other, and you have to follow the rules. Another mechanism you can use is you can file a bond claim, or this is often called at the federal level the Miller Act, which is the statute that allows you to do that. Or you can do it by a state statute, and most states have what's known as Little Miller Acts that allow you to enforce bond claims. Now, those are usually required on public projects, but not necessarily on private projects. So that's possible too. And then you have prompt pay statutes, which some states have and some states don't. And those give you additional rights those are meant to protect downstream contractors, just give them a little additional leverage. And we'll go over those in a little more detail later. So when do you call your attorney? Well, if you're having trouble getting paid on a job, we generally recommend that you talk to your attorney earlier, as soon as you're starting to have some trouble with it. I don't know how many times we've had someone call us and say, hey, we had this job that we finished up last year and I'm having trouble getting paid on it. Can you help me? And sure, we can help you, but our options are a little more limited if you wait a whole year like that, because generally, mechanics liens and bond statutes, they have pretty strict limitations on timing mechanisms, and that can limit your rights if you wait too long. So, if you ask us earlier on, we might be able to help you get those stronger enforcement mechanisms a little bit earlier in the process while they're still available. We always like to say you're better off being proactive versus reactive. We can look around the corner for you, and we can help you avoid a small payment problem turning into a bigger problem, maybe because the job goes bad and more subs don't get paid, or for any number of reasons. It's better to always be thinking ahead and knowing what all of your options are instead of just reacting to bad things that happen. The deadlines are actually very short, particularly with mechanics liens. They vary from state to state, but you're often looking at only 90 days to take certain acts, or even a handful of days for certain steps in some mechanics liens statutes, in order to make sure that you preserve your right to bring a claim. And if you don't follow these steps, then you might not be able to get your lien rights preserved. Now, going back to some of your standard provisions for trying to get paid, one is a demand letter, of course, and this might be a better first step before you want to escalate things, because a lien is a pretty big, drastic action to take on a project, and people have to preserve relationships, and we're certainly always sensitive to that. The demand letter can come sometimes from you yourself, and we can just help you ghostwrite it, or it can come directly from us, which sends us a little bit of a stronger message. It's really important when you write a demand letter that you show that you have your documentation, and that the letter itself serves as documentation of the issues that you're having. You show that the claim was asserted, you point out contractual notice provisions, you make sure that you preserve your claim with this record, and so that later if it comes to being in court, it shows that you were reasonable and you tried to work things out, and judges do like to see that. And it can help box the other side in by showing that there's this pattern of them refusing to pay you even though you've done all the work. Okay, so mechanics lien. So if push comes to shove, you might need to threaten or even take steps to file or record a mechanics lien. These are usually available only on private jobs. Now, the upside to a mechanics lien is that these give you big time leverage. It generally gets the owner's attention because it means that there is now an encumbrance on the property itself. So, you might have let's say you're a subcontractor and you have a contract with the general contractor. Now, the owner might not even know that you're not getting paid. When you file the lien on the property, that's going to get their attention, and then they're going to start putting pressure on the general contractor because they're going to want to get you paid. Now, the way the lien works is, and it doesn't usually come to this, but the ultimate remedy for a lien is to actually enforce it and sell the property so that you can get paid. Now, as a practical matter, this will never happen because the owner's not going to let that kind of mechanism get worked out through the legal process. They don't want to see their property sold, so they're going to, pay you. They're going to pay out to the sub, or they'll talk to the GC and put pressure on them to take care of it, maybe have them bond it off. But that way you still have some security. We actually had one example was we had a few years ago, we were working for a GC that was doing build out of a restaurant in DC on one of these large, downtown DC office buildings. And it was just a portion of the building. And it was about $330,000 worth of work. But the value of the entire building itself, because it was a big DC office building, was over $300 million. So the remedy for that lien would have allowed us to sell that building to pay that $330,000 debt. Obviously, it's not going to go that far, but it does show that it's a very powerful tool. But because it's so powerful, the legislatures create a lot of hurdles that you have to get over. There's a lot of rules that you have to follow and deadlines that you have to follow to make sure that you're able to actually get the lien validly. Now, what's the downside of liens? Well, they're not easy. You've got tricky deadlines. Different states have different rules. And it's usually one strike and you're out. If you miss one deadline, then you lose your lien rights. They do this on purpose, again, so that they make it hard to do. So that because it's such an extraordinary remedy, you don't want just anybody to be able to create a lien right. So let's start with Washington, D.C. Who can get a lien? D.C. limits it somewhat so that it's only general contractors and subcontractors. So usually if you're a subcontractor or a supplier that has a contract directly with the sub, you're not going to be able to get a lien right. There's an open question as to whether or not architects or design professionals. Because DC is a smaller jurisdiction, there's not a lot of court cases that interpret the language of the statute. So you don't always know certain legal questions. A lot of them fall under gray areas, and that's the case for architects and design professionals. Generally, in order to have a right to a lien in DC, you have to have supplied labor or materials to the job. Now, the DC Recorder of Deeds has done something interesting where they've interpreted the statute to say that there's a physical labor requirement. So they won't allow design professionals to get a lien. That's actually not proper for them to be doing. It's really judges' jobs to interpret the statute, not the clerk's office. And we've gone back and forth with them on this and had to negotiate before. In order to just be on the safe side and avoid that, it's better to always list when you file your lien, you have to provide a description of the work and to make it clear that there was some physical component to that work. Now in DC, the owner has what's called a defense of payment. That means that if the subcontractor or the supplier is owed money by the GC and the owner has already paid the GC for that work before they got a notice of the lien, the owner is actually off the hook. So the takeaway from this is you don't want to wait until the last minute, until the deadline for filing your lien to get your lien recorded. You want to do it as early as possible. It's kind of a race to get the notice to the owner before they pay the GC, because then the GC might be able to hold your money. So you don't want to wait until necessarily the end of the project or your payment's overdue for 90 days before you file the lien. You want to get it in as early as possible. So what do you need to file? You can say file or record, but there's a form called a Notice of Mechanics lien that DC provides, statutory form. It's available at the DC Recorder of Deeds website. And you have to, within 90 days of the completion of your work or the termination of the project, you have to fill out that form. It's only a few pages. But you got to get certain things right in there. You have to fill it out and you have to record it with the land records office downtown. And then as soon as you get it recorded, you have to serve a copy on the owner within 5 business days. And these are key deadlines that you want to make, because if you don't make those deadlines, you might risk invalidating your lien. So what do you need to get ready? There's a few steps. You want to make sure you're organized before you file your lien. There's a few boxes you got to check. You're going to need to, when you fill out the form, provide a description of the work. And like I mentioned, include the physical labor if possible, because of the quirk of the current clerk that we have there. You're going to want to do a title search of the property, because you actually have to provide a description of the property itself that conforms with what's on the land records. The lien can actually be invalidated if you don't have an accurate property description, so you don't want to leave anything to chance there. You also have to determine, are you doing a lien on the property itself? Now, if you're just doing new construction for like a new building, there might be a lien on the property itself. If you're doing like a fit out for a restaurant or a retail store, then the owner might actually just be a tenant, and you can only get a lien on the lease. You can sometimes have both, but there's limitations on that. So if you're doing fit out work for a tenant, in order to lien the base building property and not the lease, the property owner, not the tenant, must have directly authorized the work. So sometimes you got to do a little detective work to figure out behind the scenes what's going on and where your lien rights are going to be. It's generally going to be better to get a lien on the property itself than it is on the lease, but there's still some leverage to getting a lien on a commercial lease. Another thing you need to make sure you have ready is a contractor's license. You want to make sure that you're licensed to do business in DC before you file your lien, because that is one of the requirements, and they expect you to provide a copy of your license when you file your lien. So, all right, so your first step, you got to record your mechanics lien. Then you've got to provide notice to the owner. All that has to be done within, first has to be done within 90 days of the last time you did your work, and then provide notice to the owner within 5 days. There's a third step with a timeline component to it, which is you have to file a lawsuit to enforce your lien. That has to be done within 180 days from when you recorded the notice of lien in the land records office. There's also an additional filing that you have to do with the land records called a lis pendens that just puts everyone on notice that the property is encumbered. Failure to meet any of these deadlines could invalidate your lien. So like I said, it's very tricky. There's a lot of deadlines you got to keep track of, and you have to file things with land records office. You got to file things with the court. This is why we recommend you go through legal counsel to do it. I mean, there's certainly commercial lien filing services that'll do some of these steps for you, but you know, some of them operate in a lot of different states, and it's just a little risky to do that. It's better to make sure that people know what they're doing, because you don't want to give up your lien rights. They're very important. So in DC, what are the advantages of DC versus other jurisdictions? Well, DC has better priority. To use the archaic legal term, it's incur. That means that you don't have to file your lawsuit to enforce it. That's the third step we talked about, to perfect the loan. Once you actually record it with the Recorder of Deeds office, the first step, the lien amount actually relates back to the day work started. So this is important for things like bankruptcy or sale or foreclosure of the property, because it gives you kind of your place in line earlier on. Another thing that's nice about DC's mechanics lien statute is that any repairs or improvements allow lien rights, whereas as you'll see when we get to it next, Maryland has a 15% rule or a 25% rule for how much you improve the property value. And then another advantage is the general contractor cannot waive the lien rights of its subs in its contract with the owner. So if you're a subcontractor, that's good news. Disadvantages for DC. One disadvantage is that there's no liens for remote subcontractors. You basically have to be a GC or a subcontractor in order to have lien rights. So if you're farther downstream, you're a sub to a subcontractor, or if you're a supplier who's contracted with a sub, then you're not going to have lien rights. It's a little uncertain right now for architects and design professionals, and some people would say, no, you don't have that, but you know, we don't know because the DC courts haven't ruled on that issue before. And then you have to deal directly with the owner or the GC to have lien rights. And those lien rights can be waived by contract. So, you know, one way this can happen is that, so the GC, if you're a sub, the GC can't, in its contract with the owner, waive your lien rights. However, the GC can, in its subcontract with you, get you to agree that you don't have lien rights. So you got to be careful when you sign that contract up front and make sure that you're not waiving your lien rights in it. Another way you might be able to give away your lien rights is every month you have to, usually on a job, you're going to have to sign those lien waivers that you submit with your payment applications. If you look closely at the language there, you'll see that a lot of times you're giving up your lien rights, and courts generally will enforce that, even though, you know, you already contracted to do that work and you already should be paid for the work you've done. They'll still allow you to waive it just by signing that. So you got to be careful about those. Okay, let's talk about Maryland now. Maryland has a couple of components. It's actually fairly different from DC. The first thing you have to do with Maryland is you have to provide notice to the owner and the general contractor that you're going to pursue a lien claim. Now, if you're the general contractor, you don't have to do that because the owner already knows, how much money you're owed. But if you're a subcontractor or a supplier, then you're going to need to provide a notice of lien claim within 120 days of the last day that you did work on the project. Now, what does that mean, last day of work? Well, if it's one contract or a continuing contract, then the deadline will actually be extended by later deliveries ordered by the owner or later, services that you provide. If it's a purchase order, that usually counts as a separate contract. Statutory form notice is required by Maryland. It's basically the statute has certain components that have to be in this notice. And they're listed in the statute itself, and there's a form that you can get online for this. But what it expects of you is that you're going to need to accurately describe the building or the property. You can do it with the mailing address, but it's usually better to provide the real property information, lot, square, whatever. You have to accurately identify the owner. You're going to need to identify what work you did or materials you furnished and when you provided them. So step one is you have to provide notice unless you're the GC. Step two is you have to file your lawsuit to enforce the mechanics lien. So it's more of a two-step process in Maryland. Now, this is basically the lawsuit that you would file, and Maryland, some jurisdictions don't let you do this, but Maryland's one of the states that does. You can file your petition to establish and enforce your mechanics lien along with, your breach of contract claim because, you have multiple bundles of legal rights here. The lien claim is more of a claim on the property, whereas breach of contract is more your claim based on your contract with the owner or the GC, whoever you're doing the work for. So it's, there's two different types of rights that are tied up there, and both can give you additional leverage. So you want to make sure you maximize your bargaining power. So hopefully you can get things resolved and you can get paid. So the lawsuit called the petition to establish a mechanics lien, that's going to need to be filed, usually in Maryland State Court, within 180 days of the last work that you did. Now, a key difference here, remember in DC, what we were just talking about before, your lien was incur. That means that it related back to the date that you did the work, and you perfected your lien just by filing it with the Land Records Office, just by completing step one. Maryland doesn't even give you that with step one or step two. Your lien is not considered valid yet. You've just kind of said, hey, I have a lien, but it's not a real lien yet. So Maryland has a different quirk where it requires something called a show cause hearing. It's almost like a mini trial on your lien to establish, okay, these guys did this work. Okay, they met all their deadlines. Okay, they've got a real claim here. Now we can go to discovery, but we're going to go ahead and the court's going to kind of stamp this and say, all right, now you have a valid lien, but you actually have to get in court to do that. Now, the nice thing is Maryland mandates that hearing take place relatively early on. It's supposed to be within 90 days of filing to enforce your lien. Best practice is to file a petition to establish and enforce the lien. Maryland actually says you could do it in multiple steps, but it's just never done that way. So this is the lawsuit again to establish the validity of your lien. And there's certain requirements that have to be in there by statute. You got to make sure you include this information in there. You want to have the name and the address of the claimant, the petitioner. You need to have the name and address of the owner of the property. You need to have a description of the work that you did and the amount of materials you furnished. And you also need to provide a description of when the work was done so that the court can assess whether or not you met the deadlines for filing and providing notice and everything. You need to provide the amount that's claimed to be due, less any payments. So you got to show credit for any payments that are made. You got to get the amount, you want to make sure that the amount is as accurate as possible because you don't want to risk any kind of argument later on that you filed an improper lien. You got to provide a description of the land sufficient to identify the building. If you're doing work on a project where there's multiple parcels of land, this is why you got to do, we recommend you do a title search so that you know that you have the accurate descriptions of the property. There sometimes might be work that's done on multiple parcels of land. So you're going to have to allocate which work was done on which parcel and show which amounts are owed per parcel. So that can be tricky too. And then you have to provide an affidavit setting forth facts to establish the lien. That's basically a sworn statement from someone. It might be, the owner or the project manager of the company that's claiming their lien, that they actually did the work and that they're owed the money. And then you're going to want to provide copies of all the documents that help establish the lien. Usually that's going to be payment applications or some kind of contract accounting along with your subcontract. Maryland does not, unlike DC, Maryland does not allow waivers within your contract itself of your lien rights. So if someone puts a provision in there that says subcontractor waives all rights to any liens arising from this work, that would not be enforceable against you. That would be void as against public policy in Maryland. DC allows that to happen. Maryland does not. However, you can still waive it in a separate document. Usually the way this comes up is the industry standard partial payment claim or lien waivers. Those partial lien waivers that you sign usually every month will often have language in there. And unless you strike it out or mark it up in some way saying, I don't waive my lien rights, you might be signing away your right to claim any liens later on. So what are some unique features of Maryland? Well, Maryland allows you to lien just about every building, including wharfs, bridges, certain utilities, etc. As long as it's new construction or repairs, improved or rebuilding. But if it's not new construction, then Maryland has a separate rule for it. If it's work for an owner, you have to be rebuilding the property or improving it by at least 15% of its value. Now, sometimes this is a factual matter that you might not know with certainty, but you want to at least have a good faith estimate of the improvement value in order to have a valid lien claim. Otherwise, there might be a valid defense to your lien. And then if you're doing work for a tenant, then it has to improve the property by 25% of its value. And that's not just the work that you did. If you're just one subcontractor on a bigger project, it's actually a measure of the whole project has to improve it by that amount. Maryland does not have an affirmative defense of payment. That means that the lower tier can lien work for which the owner has already paid the GC. So if you're a subcontractor and you provide notice of your lien claim, the owner can't say, oh, I already paid the GC for your work. Sorry, the owner is actually obligated to pay again if that's the case. And then, of course, another Maryland specific that we discussed is the show cause hearing. That's where you get what's called an interlocutory lien. It's like an initial valid lien claim that you have. And then you allow, once you get that set up with that interlocutory show cause hearing, then you might have your traditional discovery and litigation that goes past that. Now, as a practical matter, once you get that interlocutory hearing and establish your validity, that your leverage usually goes up then, and that's a good time to be able to resolve things with the owner or the GC. Some of the disadvantages of Maryland is that a sale of the property before establishing the validity of your lien destroys your lien rights. So you really want to get to that show cause hearing as early as you can. So you don't want to wait the full 120 days to give notice, 180 days to file your lawsuit. Sometimes you want to get in there as early as possible. There's no sense in waiting because you don't have a valid lien yet. As soon as you file your lawsuit, then you start the clock. So then you've got 90 days for the court to set up your show cause hearing. And then once you get through that hearing, then you've got a valid lien, hopefully, as long as you get past all the hurdles there. Liens that are within 90 days of a bankruptcy filing are invalid. And then the lien is inferior in Maryland to a construction loan deed of trust, judgment lien, or anything else recorded on land records. So Maryland has some disadvantages there, that it's not as good a priority on your lien claim for certain other, vis-a-vis certain other debts. And like I said, the priority does not relate back to when the work began. Okay, so Virginia. Virginia is a very tricky jurisdiction for getting lien claims. You know, it's in some ways it's similar to DC as far as the general structure, but there's some additional requirements in there that make it somewhat confusing and not intuitive. So it's, you know, especially for Virginia, it's really recommended that you secure legal counsel to review your lien rights. Now, the nice thing about Virginia is it's similar to DC in that once you establish your liens have pretty high priority over other property interests, unlike Maryland, which we saw, you know, certain other things can kind of jump you in line if you're a creditor. So who can get a lien in Virginia? Virginia allows anyone in the contract chain of labor and materials to have lien rights. So are you a third-tier contractor? Yes, you get a lien. Are you a second-tier supplier? You get a lien too. Architects, design professionals, it's generally accepted that they can get a lien as long as they provided labor and materials to the property and didn't just do kind of, you know, home office design work. Virginia is like DC in that the owner has the defense of payment. So if a subcontractor or supplier is owed money and the owner has paid the GC before they receive notice of that lien claim, the owner is off the hook because they've already paid for that work. Again, don't wait until the deadline. Get your lien claim in early. You don't have to wait until the project is completed to file your lien. And you'll see in a moment why this is particularly important in Virginia and why that's the case, that you don't have to wait until the end of the project. Now, for Virginia, it's somewhat similar. It's roughly similar to DC in that you have to file a notice of mechanics lien in the land records office. Now, DC is just one kind of mini jurisdiction. There's one land records office. In Virginia, there's not a centralized office. It's going to be the land records office in each county where the work was done. You have 90 days from, it depends on whether or not the project wrapped up in the month in which you were doing the work. You have 90 days from the last day of the month in which that lien claimant last performed labor or furnished material. However, it can't be any later than 90 days from the date that such building, structure, or railroad is completed or the work thereon otherwise terminated. So if you wrap up construction on project-wide in that month, you've only got 90 days from, let's say it was March 12, you've got 90 days from March 12, as opposed to if construction did not complete in March, you've got from the end of March, you've got 3 months after that. For the lien notice, the notice you have to provide, subcontractors and suppliers, they need to provide notice in writing to the owner of the property. General contractors, they need to provide notice to the owner, and they also have to provide a certification that notice was provided when they file the the lien with the Land Records Office. Here's where Virginia gets really weird and tricky. They have this extra 150-day rule, and there's really like deadlines that, and this is tricky to get your brain around at first, but it makes sense once you understand it. There's deadlines in both directions. You have to get your lien claim in within generally 90 days, 3 months of when you did your work, but you can only count back 150 days worth of work. So anything beyond, 150 days in the past, you can't actually claim a lien for any of that work. So that means that if you have a project that's going to be, a year long and you're already experiencing payment issues midway through the project, well, you need to start your clock, your 150-day clock, because you might need to make multiple lien claims on that, because you're only allowed to assert a lien claim for 150-day chunks at a time worth of work. And this is a little tricky, and it's almost not practical, because you don't have necessarily 30 days worth of work in a month. And usually you keep track of all your billings, and you pull them together on a monthly basis and say, here's my invoice. But you're actually going to have to split up some monthly invoices and pay apps and figure out, well, which work was done going back to 150 days ago. It might just put you on the 8th of the month, and then everything before that's a separate bundle of claims. So it can get really tricky, and you often have to make sure that you're going to want to talk to your legal counsel and try to figure it out, because you might have to make multiple lien claims, and you've got to be careful about how you count up the amount of days that are in each lien claim. But because of this, Virginia does allow multiple lien filings on one project. So when you're getting your lien ready and you're pulling all your stuff together for making a lien claim in Virginia, make sure you have a description of the labor and material that you supplied. That's usually not too hard. Again, you want to do a title search of the property, because your lien can be invalidated if you don't provide an accurate description of the property. And then again, like we talked about in DC, are you trying to get a lien on the lease? Are you trying to get a lien on the property? Well, ask yourself, did I do this work for a tenant? Is it the owner of a restaurant and they just have a lease of like a larger building? What am I dealing with here? You got to ask these questions and make sure you understand what you're leaning here, because if you lean the wrong thing, your lien could get invalidated. You need to make sure that you're licensed to do business in Virginia as a contractor. You have to certify that this has been done. And then if you're doing a residential job, there's a little extra requirement. You have to actually register for pre-filing with a mechanics lien agent, provide notice by certified mail within 30 days of beginning to supply labor and materials. And they do this as more of kind of a consumer protection measure for residential construction on smaller residential projects. So Virginia follows the general model that all the jurisdictions follow, which is first you got to provide notice, then you've got to file a lawsuit to enforce your lien. Virginia requires you to file your lawsuit in the circuit court of the county in which the work was done. Of course, that's also going to be the county where the land records office is, where you filed your notice of lien. You have to do that within the later of either 6 months from the date that you filed your notice of lien, or 60 days from when all the work on the project was completed or the project was terminated. If you don't meet these deadlines, then your lien can be declared invalid and no good. So again, you get a lot of power with these liens, but they don't make it easy on you. They make it really tricky, and there's a lot of hurdles you got to get over, a lot of hoops you got to jump through in order to establish a valid lien. An advantage of Virginia has a lot of tricky requirements, but it does give you pretty strong priority and lien rights once you are able to establish your lien. Like DC, as far as a creditor determining when your place comes in line, Virginia liens relate back to the date that the labor and material is supplied. And the lien also survives sale and foreclosure of the property by an inferior lien. Another nice advantage of Virginia, unlike DC, is that there's no known limit on subs or suppliers. So you can go all the way down the contractual chain. You just have to trace that your labor and materials were provided to the property. You can file multiple liens in Virginia, and you can get lien rights for just about any kind of work. There's no requirement that you improve the property by a certain percentage of its value like Maryland does. Disadvantage of Virginia, like we said, time limits are complicated. It's not intuitive, so it can be very tricky to navigate that. Split out your documentation to make sure that you're complying with the 150-day look-back rule. Another disadvantage, in my experience, Virginia courts are very strict with the deadlines. This is generally true for most states. Most states are very strict with the statutory deadlines for any kind of mechanics lien that you're claiming. But Virginia courts are, they're kind of a tough luck jurisdiction. They expect you to follow the rules. And that includes the 150-day rule. If you try to claim amounts outside, let's say you just go over by a few days. Let's say, well, 150 days goes back to March 3rd. Well, let's just squeeze in the work that we did on March 1st and March 2nd. What are they going to do? Just shave off those 2 days at the worst, right? No, you might actually lose your entire lien because you tried to squeeze in 152 days of work. So you got to be careful about that in Virginia. Virginia also requires you to allocate based on multiple parcels, similar to Maryland. That can also be tricky. And again, if you get it wrong, if you say work that you did on one parcel was actually done on another and you don't have the correct information there, that could invalidate your lien. That provides a valid defense for the owner. Okay, so we've talked about lien rights. Lien rights are some of the best and strongest mechanisms you can use for getting paid, but they're only available on private projects. The government doesn't want you filing liens on government-owned property, so they've provided a different form of security to protect downstream contractors. Usually this takes the form of payment bonds. So we'll talk about bond rights. Now we're talking about payment bonds, not performance bonds. I think most people understand the difference, but I just wanted to be clear. Payment bonds are what you post to make sure that your subs get paid, and if you're a lower sub, then you want to look to that as a security to the surety who posted the bond. Now these are generally, even though these are contracts, they're a contract that you are not a party to if you're trying to be a bond claimant. So there's a statutory mechanism that says you have a right to that bond, to that security. And these are called Little Miller Act statutes. And this is similar to the federal Miller Act, and it usually doesn't deviate that much state by state. It's pretty similar to the federal act. For public projects, this applies to projects that are done by the state, by a city or municipality, by a town, by a county, and by, state agencies or county agencies. Now, private projects sometimes can have bonds too. It can be harder to get a hold of those bonds or to even know if a private project is bonded, but sometimes you have to do some detective work, and that can be to your advantage if you're able to determine that. Now, there's a two-step process for bonds. One, you have to provide notice to the bond principal if you don't have a direct contract with them. So if the GC posted a bond and you have a contract with the GC, you don't have to meet the notice requirement. You just have to do step 2, which is file the lawsuit to enforce. Notice details can vary by state. If you do have to provide the notice, generally it's going to need to be within 90 days of the last date that you did work. Now, what's the last date that we did work? And this is kind of a tricky question that comes up with mechanics liens too. The best practice is to count your deadline from the date of the last substantial and new work that you did. If you're just coming back for like trivial punch list stuff and repairs or warranty work, that might not extend your deadline. You want it to be stuff that's within the original scope or directed change orders that you're doing on the project. Most states aren't going to let you come back and extend your filing deadline by saying, oh, well, we had to come back and do this warranty work. And then in the notice that you provide, you're going to need to state the amount of your claim with substantial accuracy. Step 2, the enforcement. Generally, it needs to be done within a year of the last work that you did. So you've got a 1-year statute of limitations there. You also have to wait at least 90 days after the last work that you did before you file suit. And that's usually just to make sure that you're not overlapping with the notice provision, but even if you don't have to provide notice, you do have to wait that 90 days. There's no defensive payment with bond claims. That is, the general contractor has to make sure that all covered subcontractors and suppliers have been paid. What are the state deadlines? DC and Virginia are pretty much the same. The notice must be received by the bond principal, usually the general contractor, by certified or registered mail within 90 days of the claimant's last work. And then the lawsuit must be filed more than 90 days after the claimant's last work, but within a year. Maryland's a little different. Maryland actually says that it has to be, that your lawsuit has to be filed. It doesn't say clear there with that bullet point, but that's to be clear. The lawsuit has to be filed within 1 year of the public body's acceptance of the work. So even if you haven't been on the project for a while, that time period can be told by the whatever the public body is that's overseeing the project. They have to sign off on everything that's done, and that might give you some additional time. Now, once you are able to get a hold of the bond, and sometimes that's not easy, they're supposed to provide it when you ask, but I'm sure everybody's experience is sometimes they don't. Just make sure that you ask in writing. But the language of the bond itself may provide some additional rights than what is required by law. They can't provide less rights than what are required by law. And then second tier material men, usually a supplier to a sub or a supplier, those generally do not have bond rights. How do you get a copy of the bond? Well, think about it. You can always, if it's a public project, you can actually submit a Freedom of Information Act request. Generally, those procedures are more robust for most federal projects and easier to get a hold of fairly quickly. When you're dealing with state agencies, most states have their own state-level FOIA statutes, and it can really, in my experience, it varies from agency to agency. Some state agencies are good about it and do it right away. Others, you might have to turn the screws on them a little bit and put some pressure on them, and even sometimes file a lawsuit to get the information you're looking for. But that can get you valuable information, not just a copy of the bond. I mean, you can get a copy of payment records and find out, the GC, let's say you're a sub and the GC hasn't paid you in a while. Well, we don't know if the owners paid them for the work, and that's kind of an important thing for us to know. So you can actually demand from the public body payment records to show how much has been paid and whether or not they've been paid for your work, whether or not, all the change orders you have pending have been approved. All right, so let's say, setting aside mechanics liens and bond claims, we've also got prompt payment statutes. These vary quite widely from state to state. These are, aside from these enforcement mechanisms, these are additional rights that you might have to get paid. Now, you might have terms in your contract about when you can get paid. And you might even have some provisions in there about whether or not, if there's a dispute and one party prevails, prevailing party gets attorney's fees. But that's not necessarily going to be in there. You don't know. And a lot of times that won't be in there, and it's just, that means that you got to pay a lawyer to go after someone who's refusing to pay you. And the general default rule in the American legal system is that both parties pay their own attorney's fees. So that, creates a bit of a disparity in bargaining position when, the downstream contractor is usually smaller. They're usually the smaller entity, and so they have to pay more to get the money for the work that they did, which is, unfair. And I'm sure everybody's been in that position before. Well, these are another way that states will level the playing field. Some states do a better job of that than others. These are state statutes, prompt pay statutes, that provide incentives for the upstream contractor or the owner to pay the downstream contractor. Now, the nice thing about these is sometimes they can have mandated statutory interest, and then they can also provide that you are required to pay the attorney's fees. Now, as a practical matter, that's not going to come until later on. It's usually more about creating leverage. Whoever's refusing to pay you has to think, well, if we don't pay them now and we fight over these change orders that we made them do before they, we got the pricing from them and we said we didn't agree, but we told them to do it anyway, and now they want their money. Well, if we keep fighting them, then we might have to pay their lawyers eventually, so maybe it's not worth it. So that's why those are there as a practical reason. DC has a good prompt pay statute. It's only 7 years old, but it's pretty good in that it has robust protections. It provides protection to contractors or subcontractors where the owners of the GCs fail to timely pay undisputed amounts. Now that's defined in the statute as an amount owed on a contract or a subcontract for which there's no good faith dispute, including any retainage withheld. As a practical matter, I mean, we haven't had this defined by the DC Court of Appeals yet because it's a fairly new statute. A good rule of thumb is probably to say if you have amounts that are still owed on your contract balance and extras, even after all the back charges they might have against you, then that's probably an undisputed amount. The nice thing about DC's prompt pay statute is that not only can you recover interest on the unpaid balance, you can also get attorney's fees. This applies to construction contracts, and they define that to mean to provide labor, materials, or both for demolition, building, renovation, alteration, or maintenance of buildings, roadways, and structures. That's property owner or tenant work. It is not work for DC agencies. It's just work for private construction. And this applies to all contracts entered into on or after October 1st, 2013. Probably safe to say at this point that applies to your contract. DC also defines what is a contractor. I'm just going to skip through a few of these slides, and I think we'll make these available to everyone if you want to read the details later. But it does, bottom line is it protects contractor with the prompt pay statute and defines it, protects subcontractors, that's first or second tier subs who have not been paid, and that's defined there as well. And it provides that undisputed amounts have to be paid to them within 7 days after the upstream contractor receives payment for the work. So if you're the first tier sub, the GC has to pay you within 7 days of receiving payment from the owner for your work. So once you find out that that happens, the light bulb should go off and say, aha, that means I now have prompt pay rights, and you want to make sure that you assert those. The penalties for failure to pay in DC, you get interest on 1.5% per month on any undisputed amount that's not paid on time, which is a pretty hefty interest penalty. And then you can get costs and reasonable attorney's fees, assuming, of course, if you sue and win. Now, Maryland has two sets of statutes that deal with prompt payment. DC only has one that deals with private projects. Maryland has one for both private projects, and then it has what's really more of a dispute resolution procedure for public projects. Maryland's applies fairly broadly to different types of construction, the Private Prompt Payment Act. It doesn't apply, however, to single-family houses, home improvement contracts, or contracts with state or other public entities or authorities. So they want to limit it to the more commercial scale construction. Claims can be made by the contractors directly, payment claim against the owner, and also with subcontractors and suppliers. Like DC, it applies to all quote-unquote undisputed amounts owed under the terms of the contract. Untimely payment for GCs, if the contract is silent, full payment is due within 30 days after the occupancy permit is granted or the owner takes possession, whichever is first. If the contract does specify a payment date, then payment must be paid within 7 days of that date. For subcontractors, if the contract is silent, the subcontractor has to be paid all undisputed amounts within 7 days after receipt of payment by the upstream sub. Still unclear what disputed in good faith means. Consequences of untimely payment. You can also get equitable relief, which enjoins further violation. You can get interest and costs, and then you can get your attorney's fees. Maryland also has a general procurement law prompt pay statute. It's really more of a dispute resolution mechanism, and it's pretty complicated, and we're running short on time, so I'm not going to get into the details. But you should just know that there's a similar mechanism for dealing with public entities who haven't paid on time, and it allows you to invoke certain protections, and within certain deadlines that are pretty prompt, they have to work with you to make sure that they pay you for overdue bills. Virginia, last but definitely least, has only one prompt payment statute. It is not for private projects. It is only for public projects. They provide protection to any privately owned entity that contracts with a Virginia agency. It also protects subcontractors by requiring payment clauses in the subcontract for timely payment to the subs. There's no payment protection for private projects. And the big downside of Virginia is you don't get any attorney's fees for non-payment. The only protection is you get interest at the rate of 1% on the undisputed balance per month. The contractor protections for Virginia, it's for anyone that has a contract with the VA agency, and it requires that all state agencies have to pay for completed goods services by the date provided by the contract, or if there's no date specified, the latter of 30 days from the date the goods services are provided or from the invoice date. This also applies to local government agencies as well. There's just a slightly different timeline for that. Now, if there are any issues on providing timely payment, then the agencies are required to provide notice of those issues within 20 days of the date that payment is due. There's also a requirement that applies for subcontractors. All contractors who have a direct contract with the government agency have to include a payment clause in their contract that they will pay their subs on time, that within 7 days after receiving payment for that work that the sub did. The interest rate is 1% per month for unpaid amounts that have not been withheld in accordance with the statute. That is, you provided notice of the reason that you couldn't pay. And subcontractors have to include these clauses in their subcontracts. Virginia does not give you attorney's fees. Okay, so I think that concludes our webinar for the day. Thank you so much for tuning in with us. It's a very nice day outside in the DMV. I don't see that we have any questions pending, but feel free. We'll circulate to everyone afterwards that registered. Some information if you want to, my contact info if you want to follow up if you have any additional questions. I'd be happy to talk to you about it in person and answer anything that you want to post. So I hope everybody is doing well and staying safe, and thank you very much for attending our webinar.